Welcome to the General Data Protection Regulation GDPR online course. Module 8 consists of 4 lessons. Lesson 1 refers to the data breaches and explores the ways they may happen. In addition, it presents the sanctions for non-compliance and consequences of unlawful processing under the GDPR. Lesson 2 addresses the civil and administrative penalties and how to determine the criteria of the fine. Lesson 3 continues by addressing the criminal sanctions under the GDPR and presents the European Data Protection Board. Lastly, Lesson 4 explores the consequences of unlawful processing of personal health data with the use of a case study. Now we continue to Lesson 1, Data Breaches, Remedies, Liability and Sanctions Regime for Non-Compliance. The lesson objectives are understanding the breach of personal health data and understanding the consequences of non-compliance with the regulation or the general processing of personal data in its organization. This lesson will help you to understand the risks associated with data breaches in the healthcare sector and learn how to implement robust security practices to safeguard patient data, reducing the risk of data breaches. Data breaches and remedies. Regarding the data breach, it is important for the healthcare facility to have a clear and understandable privacy policy to minimize the risk of a data breach. The facility should make sure that has the appropriate procedures in place to identify, report, and investigate a personal data breach. For example, if some personal data is lost or disclosed to the wrong recipient. A breach may result from theft, deliberate attacks on systems, equipment failure, unauthorized or malicious use of personal data by a member of the staff, accidental loss. Staff should also be trained on phishing, cloud technologies, ransomware attacks, etc. Sanctions for non-compliance, consequences of unlawful processing. The consequences and sanctions for non-compliance and unlawful processing of personal health data can vary depending on the specific laws and regulations of the jurisdiction in question. Sanctions outlined in the GDPR. Here are some of the key sanctions outlined in the GDPR. Administrative fines. These empower regulatory authorities to impose administrative fines on organizations that violate data protection laws. Legal claims and compensation. This can include financial losses, reputational damage, emotional distress, or other harm caused by unauthorized processing. Criminal penalties. This can include imprisonment, substantial fines, or both. Regulatory enforcement actions can issue warnings, reprimands, or orders to cease the unlawful processing of data. Temporary or permanent bans on data processing. This means the organization may be prohibited from collecting, storing, or processing personal health data until the necessary compliance measures are implemented. Reputational damage. Use of data breaches or unlawful processing can result in public scrutiny, loss of customer trust, and damage to an organization's brand and reputation. It's important to note that the GDPR allows each EU member state to introduce additional specific sanctions and remedies, so the precise consequences may vary to some extent between countries. Additionally, supervisory authorities have restriction in applying the sanctions, taking into account the specific circumstances of its case. Civil penalties under the GDPR. Under the General Data Protection Regulation, unlawful processing of health data can lead to civil penalties that are sanctions imposed by a court or other legal authority in response to a violation of the GDPR's provisions of data protection. it's important to note that civil penalties and remedies may vary depending on the specific laws and regulations of each EU member state under the regime of the regulation. The civil penalties for the unlawful processing of health data under the GDPR are: 1. Legal action by affected individuals. Individuals whose rights have been violated due to the unlawful processing of their health data have the right to bring legal action against the data controller or processor. They can seek full remedies through the court system to enforce their rights and claim compensation for any damage suffered. 2. Compensation for damages. If an individual can demonstrate that they have suffered material or non-material harm due to the unlawful processing of their health data, they may be entitled to compensation. The compensation may cover financial losses, emotional distress, reputational damage, or other harm caused by unlawful processing. 3. Class actions. The GDPR allows for the possibility of class actions or collective redress in certain circumstances. This means that groups of affected individuals who have experienced similar harm due to the unlawful processing of health data can join together to bring legal action against the responsible data controller or processor. 4. Burden of proof. In civil cases related to the unlawful processing of health data, the burden of proof lies with the affected individual. They need to demonstrate that their rights have been violated and that the processing was unlawful and that they have suffered harm as a result. The defendant, data controller or processor will have the opportunity to present their defense and challenge the claims made against them. 5. Court order remedies. If a court finds that the processing of health data was unlawful, it can issue various remedies or orders to rectify the situation. This can include injunctions to stop unlawful processing, orders to erase or rectify the data, or other measures aimed at protecting the rights of the affected individuals. Questionnaire. Please proceed to test your acquired knowledge with the following questionnaire. Thank you for participating in Module 8, Lesson 1.